Good morning. Welcome to the First District Court of Appeals. Today is Tuesday, June 14th. We only have one case scheduled for argument this morning. We do have 4 cases on the docket, so I'm going to first call the 3 cases that have submitted on their briefs, and then I'll be calling your case, okay? So the cases that we have that have submitted on their briefs are cases number C210459-460, State of Ohio versus McVean. We also have case number C210519, State of Ohio versus Thomas. And the last one we have submitted is case number C210628, State of Ohio versus Harris. The case that we have scheduled for argument this morning is case number C210591, in re CR. If attorneys can please identify themselves and their readiness to proceed. Good morning.
Good morning. Brad Berry, counsel for Franklin Veronica Renfro.
Good morning. If you can come onto the podium. Good morning. So you have 15 minutes to argue. You can reserve whatever amount of those 15 minutes for rebuttal. How much time would you like to reserve?
Let's reserve 4 minutes.
Okay, so that gives you 11 minutes, and you can start whenever you're ready.
Thank you, Your Honor. Good morning again. James Whitfield, represent Mr. Jones, and I'll start with the timeline here. I'm sure the court's reviewed the briefs, but this young man, Cameron, was born February 8th, 2020. And at that time, it was assumed that another man was his father. Grandparents, Mr. and Mrs. Renfro, they filed for custody days later, and it wasn't until 4 or 5 months later, on June 9th, 2020, in the court appearance, Mr. Jones was mentioned as a possible father of Cameron.
So I'm going to bring you back to your statement of that it was assumed that another man was the father. Can you please share what is in the record to support that?
It was noted that I think service was made on a John Doe, but there was a gentleman, I believe, that the mother has other children with. And she's been in a long-term relationship with him.
But he knew that she was pregnant, right?
Mr. Jones or this other?
Yes, Mr. Jones.
Mr. Jones knew that she was pregnant.
Yeah.
Yes, sir. Yes, sir. And I'm sorry, I can't find the name. I don't want to miss the name.
But, well, the name isn't important, but there was someone that what was in the record that establishes that there was some belief that there was someone else that was the father. You don't have to get with, name specificity.
It was in the journal query. I have the journal query in front of me. I'm trying to read that.
Was there something on the birth certificate? Was that? Or there seems to be some confusion on that.
I don't know if there's anything put on the birth certificate at first. I know early on the case.
You're talking about in the decision of the magistrate? You're talking about mother had first given the name of an alleged father for Cameron as Bethel? Is that what you're referring to?
That was in June. Before that, there was another gentleman who was named as a possible father.
Okay.
Mr. Jones was first named in June, so that was 4 to 5 months after the original custody petition was filed.
Okay.
That's when Mr. Jones was first named.
And when you say first name by the petitioners?
First named by, I believe, mother.
Another.
The person who identified him.
Okay.
And in August, a couple of months later, that time that Mr. Jones appeared in court, and by that time he indicated he had initiated a process to establish paternity. He was not granted parenting time. He asked to see the child. The court felt that it could not award him parenting time at that point because he was not a parent. So that was in August, the end of 2020. He was ordered to appear, Mr. Jones was ordered to appear to take paternity testing in September, actually September 24th, 2020. And then there was another pretrial in this case in October, the end of October, October 28th, 2020. At that point, the matter was set for trial. in March of 2021.
Does it typically take that long from the September to February to get the results of paternity? I mean, that just seemed.
It's random. I don't know if Mr. Berry would agree with me, but it's kind of random. Sometimes it's quicker. It usually takes 4 to 6 weeks at a minimum.
Right.
Sometimes it takes longer. The processes in juvenile court, as the court is probably aware, it's a slow process from beginning to end anyway. But especially when paternity is established or attempting to be established, if there's a backlog, obviously there's COVID, things of that nature. So it's been a little heavier the last couple of years or so. But typically it's supposed to be 4 to 6 weeks, but 8 to 12 weeks doesn't really surprise me too much.
Okay. Because, obviously you're talking about the abandonment determination by the trial court.
Yes, ma'am.
So what is your position as to why there is not abandonment and that shouldn't apply in this case?
Well, technically, if you read the statute 2151.011, a child shall be presumed abandoned when the parents of the child have failed to visit or maintain contact, et cetera, et cetera. In this case, my client was not legally established to be a parent until sometime in February 4th, 2021 is when paternity was established. At that point, he became a parent. I don't think 2151.011 defines parent, but 3111.01 defines parent and child relationship. And they state parent and child relationship means a legal relationship that exists between a child and the child's natural or adoptive parents. So,
now there has been, the court relied on the fact that they were living together and that he had maintained contact and that he knew that she was pregnant. And there is a case out there where an individual had been kind of held himself out to be the father of a child, even though the paternity had not been formally established, and it was deemed that the 90 days applied nonetheless, even though paternity had not been established. So how would you differentiate this case?
I would differentiate this case in several ways. The first way, they were living together for some time, but then Miss Renfro, the mother, she resumed residing with this other gentleman. Like I said, they have children together, and they lost contact. When I say they, mother and Mr. Jones lost contact at some point. He didn't even know that the child had been born. He knew she was pregnant, but no one talked to him about anything, the child being born, birth being given. He found out through the court process. So he never had a chance to hold himself out as the father. As soon as he found out that I possibly have a son, through that notification that he got in court, he appeared at court, and ever since that time, he's done everything he can do to try to establish his rights as a father, to try to see his son more often than not. And I don't know the exact case you're citing, but there are several cases that note when you have a parent who has made attempts to see a child or attempts to be involved in that child's life, and those attempts have been thwarted. Similar to my argument is that Mr. Jones made attempts to see his son in the earlier phase. However, he was denied because he was not yet a parent. If those extenuating circumstances exist, then a parent can be deemed to have abandoned his child.
Well, the trial court, what they did is rely on from the date of birth until the date of Mr. Jones being involved in the case, and at that point, the 90 days had already lapsed.
Correct. At that point, and I'll make the argument, and I don't have any legal precedent for this, but I have experience to back this up. There's several cases where paternity has been established, and as we just alluded to, the court process is just so slow. If a mother doesn't allow a father to see his child for 90 days, even if he wants to see the child, I've never heard that anyone say that father has abandoned his children. It's just that he hasn't initiated his.
There was I think the grandparents had offered to allow him to come visit the child, but it was on a location that he didn't want to go to or something like that.
My understanding was that they offered to have some supervised visits at Holly Hill, which is a facility in Kentucky, I guess northern Kentucky, where they would allow supervised visits. And it's also my understanding Mr. Jones did not want to do that at the time. He's told me, and I wasn't there, so I don't know if this was in the record back then, he didn't know whether or not he should start seeing the child yet because paternity had not been established. Mm-hmm. After thinking about it further, 2 months later, when he went to court in August of 2020, he wanted to see the child. He asked for that and was denied. Not by the Renfros, but he's denied by the court. The court felt that because paternity had not been established, again, because he was not yet a parent, they couldn't order parenting time. So I can't speak for Mr. Jones. I don't know his underlying thinking at the time where it was offered for supervised visits. My inclination is that he did not want to do supervised visits. And then number two, I've heard again, he wanted to make sure that it was his child. And obviously he had a change of heart, or he knew something was going on, because 2 months later he was trying to see the child and had been thwarted.
Mr. Whitfield, let me ask you, it's my understanding that your client has a petition for custody. Is that still pending over the juvenile court?
It is.
And if we were to determine that the trial court was correct in determining that your client had abandoned his child, what effect, if any, would that have on that petition?
That goes to the second part of our argument and our appeal. At that point, my client would need to come in and show that there's been a change of circumstances, because it would no longer be the original custody determination. So he'd be asked to reach a higher burden, a higher standard than a quote-unquote normal parent would be, simply because paternity was established at the time and he had to wait until paternity was established, or he felt he had to wait until paternity was established before he filed for custody. So his burden would be a lot higher. You first have to show a change of circumstances to even get to the best interest standards, and then we'd have to go through that statute in order to try to obtain custody. Where our stance, our position is, this matter could have been continued out. He filed his petition. It was only 2 or 3 weeks, I think, before the custody trial was set in March. But at that point, the child had already been placed with the Renfros. The child was there safely. The child's been there ever since. We would have been in the exact same situation, however, we would have still been waiting the original custody determination. The way it worked out, again, my client's at a disadvantage, a strong disadvantage, because frankly, I haven't seen a change in circumstance yet that would get him to the best interest standards where he could actually try to obtain custody. But that's merely because the court decided to proceed on one custody petition and not the other. But Mr. Jones filed, paternity was established February 4th. I think February 25th, he filed for custody. Again, the trial was set for March 10th. They went forward on that day. And at the end of that day, he was finally granted parenting time, because by that point, obviously paternity had been established. So he received his rights. And so even if you go through the 90-day process, and again, that 2151.011 statute, as a parent abandoned their child, has it been 90 days since they voluntarily, and abandonment is defined differently, and I'll define it in just a second. But as this man, does he know that he is a child and has just relinquished his rights to it, shown no interest to his child? That wasn't the case.
There were two determinations by the court. One was abandonment and the other was detriment. So there were two determinations that the court used to support its determination of unsuitability. Why don't you go ahead and address the second?
The second standard is obviously the suitability.
I'm talking about the determination that your client would be detrimental.
Correct.
Okay.
And I'll jump to it. Case law says, and even this court has noted in the past, but just because one situation is better than another situation does not mean that, I'll just say, just because the grandparent situation, for sake of argument, is better than father's situation, that does not mean that father's situation is detrimental to the child. And that should not be the evaluation. It's not a comparison. It has to be noted that the finding of parental suitability is not something to just be taken lightly. And so, given the posture of the case, Mr. Jones was restricted from presenting a lot of evidence that could have shown his suitability. But the way that the court below kind of engineered the custody trial, he was only there to kind of defend.
And that's because his custody petition was not scheduled for that.
Yes, sir. So he couldn't present what he wanted, what I would deem that, what I believe he should have presented or could have presented to show that it was in the best interest of his child that he have custody, that he could provide a safe and stable environment, that he could transport the child back and forth to any medical appointments. Obviously, this child's young, or the daycare or whatever, that he could adjust his schedule and take care of his child. He would never got a chance to present any of that evidence. On the other hand, the burden was on the Renfros to show that he was unsuitable, and they never presented any information to show that he couldn't. But what did come out in the record was that father in the past may have engaged in some behaviors that the court might have not deemed fit or savory, but that was in the past. And when I say past, over 11 to 25 years prior to the birth of this child. but there was no evidence to show that presently he could not take care of his child, he could not provide for his child, that the child would be in harm's way with him, that he was in any way a detriment to the child. So there was a large leap to find unsuitability versus, and I think that's kind of why that was, I don't want to say it was thrown in, but
I understand what you're saying. I'm going to go ahead and reserve your 4 minutes.
Thank you, Your Honor.
Thank you. Good morning.
Morning for you.
Whenever you're ready.
Thank you. Brad Berry on behalf of Frank and Veronica Renfro. Your Honor, on behalf of the Renfros, honors, the Renfro's position supports the magistrate's decision. The magistrate very clearly went through the analysis necessary to find that this child was abandoned by both parents. That mother certainly abandoned this child and was detrimental to this child at the birth, where she attempted to visit the child.
All we have before us is father.
Okay.
So mother has not proceeded with her appeal.
Very good. Father was determined first that father abandoned this child, and the evidence clearly supports it. This child was born in February of 2020. Father first made his...
Well, so what is... I am struggling with the notion that he needed a paternity test to establish paternity, and the results of that did not come back until February of 21.
Sure.
So with that in mind, what is someone in his position to do when there's a legitimate question as to paternity?
Sure.
And I presume if in a circumstance in which maybe there's 2 or 3 people who might be the father, the court's not going to say, oh, you all get parenting time. The court's going to wait and see who is determined to be the father. So give me your position on that with respect to abandonment and how that's not a kind of violation of his due process rights.
Absolutely. And I think it's important to look at the timeline because that shows abandonment, and it's clearly in the evidence of this trial that mother and father did live together and cohabitated during the time of conception, and that father knew at the time that they were breaking up or separating that mother was pregnant. They even had a discussion, these parties, and mother told father that he was the father, that she believed that he was the father of this child. Okay, and that was before the birth. Father then came back and visited mother a couple months before the expected date, and was made aware that this is when I am due. Father chose not to appear at the birth. And to answer your question, what would typically happen if you're not going to abandon the child and you have concerns about drug-addicted mother? That's why he allegedly broke up with her, because she was drug-addicted and kicked her out of the house. And he had knowledge that she was pregnant and potentially with his child, and chose not to do anything in vitro, and then chose not to protect this child when the child was born, knowing full well that this child may be born and was born with several medical issues.
Well, the record also shows his testimony, and his testimony was that he did not believe that he was the father because of his age, and because he had had sexual relations with other women who did not become pregnant.
Sure. And
it doesn't seem as if the court had an adverse credibility determination with regard to father. So what do we do with that?
If father did believe that, that's fine, but father's own actions speak for themselves with regard to abandonment, because if there was evidence to support that he was the father, that he knew or should have known that he was the father, that he knew that there were certainly some severe medical issues with this child, potentially at birth, and then chose not to see the child at the hospital, visit child at the hospital, or to know even where child was, or if child was alive.
But doesn't that go back to whether he believed that he was the father? And his testimony, again, didn't seem to have an adverse credibility determination. And it seemed as if his testimony was bolstered by other evidence in the record with regard to other sexual relations that the mother was engaged in. And wasn't there something that she had put herself out, almost like a prostitute or something to that effect?
Sure.
So, it seemed that even though that may not have been, there was an evidence that was knowledge that he in fact had, but the evidence supported his belief that he wasn't the father.
Right. And I would argue that his belief doesn't absolve him of his abandonment of this child, that this child...
But if that's the case, then anyone who has sex with a woman and could be the father but doesn't believe to be the father is going to deem to have abandoned their parental rights if they don't get involved within the first 90 days of the birth of that child.
And I would say that I would agree with you, but this case is different in that there was evidence to reasonably believe that he could and was the father of this child based upon the fact that he was the only man living with her and having sexual relations with this woman at the time of conception.
But that seems as you're asking us to create a standard that the law does not have and to read words into the statute.
Even after the child was born, for 6 months, mother continued to believe that he was the child. Mother appeared in this case, and mother advised the court, and grandparents actually then proceeded to serve father in June of 2021. So 6 months go by between the birth and service on father, not 90 days, but 6 months where we're trying to pursue Mr. Jones and do pursue Mr. Jones. After the 6 months go by, Mr. Jones has knowledge that he's been named as the potential father of baby Renfro. And Mr. Jones doesn't pursue paternity until, I believe, September. So another 90 days goes by before he initiates his paternity action. He doesn't take any action to voluntarily contact the Renfros or to see the child. He certainly could have. The court even advised him in August, pursue your paternity rights to see if you're the father. If that's your threshold, do that. To answer the question about paternity and paternity testing can be completed in 3 days through a private test or through a test that is recognized by the CSEA. The CSEA, I believe Mr. Jones pursued it administratively instead of legally, and the court even asked, why don't we see this test showing up on our record? Because he didn't pursue it the quickest way. He went through an agency, but he also delayed in pursuing his agency request for the DNA test. I've never seen a DNA test take from September until I believe what he said was February 1st, or when he actually provided it to the court through his through his custody petition.
So I know that the trial was already scheduled at this point. He files a custody petition, and the court puts that off until later in the year. You're already having a custody trial. Why would you not? I don't understand why the court did not just join those issues, because if it was going to ultimately rule in favor of the grandparents, it effectively moots his. Why wouldn't you have all issues joined in one proceeding?
Correct. Well, I know that this matter had been pending before the court for 13 months, that it had been set for trial for 5 months. And I think that the court wanted some resolution for the Renfros. And obviously...
Yeah, but why wouldn't you just say, okay, well, you took your time getting all of this to us. You're stuck with this trial date. Put on your best case there.
Right. And I think they did. I think that even the magistrate's decision says, we're assuming that he's the legal father. And they proceeded the court even addressed it in its decision that we are still going to require the Renfros to show unsuitability, and then we're still going to go through the second prong of best interests, because they were treating it as two parents in front of them for custody. Only one parent chose to participate in the trial. But Mr. Jones was present at the trial. He was represented by counsel. He called witnesses. He testified. He cross-examined witnesses. He had the opportunity to submit evidence. He participated as if this were a custody trial. There was at no point during this half-day trial, 2-hour trial, where he was told that he couldn't participate as a full party in the action.
Well, the difference is, though, he was participating in an action where he did not hold the burden of proof, though.
And you're correct.
So there might have been things that he would have, brought forward had he had the burden of proof.
I would agree with you, Your Honor, except he showed up with the expectation that the court was going to move forward with his petition. If you look at the record, that when he appeared, the court said, okay, let's proceed, and you have paternity. And then the court looked and said, okay, do we have service on both do you have service on mother? But when he appeared with counsel, he was prepared to go forward with his custody petition. He had it filed prior to the 3 weeks prior to the hearing. So he was as prepared as he was going to be.
But you're also kind of putting yourselves in the shoes of counsel when it comes to trial strategy with regard to that. And that's something that obviously none of us know what their trial strategy was.
Well, that's true, but he had noticed that everybody was set to go to trial, and he appeared with counsel to go to trial with his petition filed, and he had not filed a request for a continuance prior to that hearing. He had just filed a custody petition.
So I'd like to ask you this, as the question that was already asked to appellant. If the case was remanded, what would happen next?
If it's remanded, I think it would be reset, and we would have another day of trial. I don't believe it's in the best interest of this child to have this instability. But it also is really hard on the Renfros, who don't have infinite funds.
But what would happen next, though? It would go back and it would go on the custody petition, I assume?
It would.
And what would be the analysis there?
I think it would be the same. It would be unsuitability and then best interest. It's the same trial that we just had.
And who would have the burden there?
I think my clients would have the burden of proving unsuitability, just like they had the burden of establishing unsuitability at the first trial, and then best interest. And we literally had that exact trial, and it would be a rerun. Only it would be giving Mr. Jones an opportunity at the second bite of an apple because he delayed. It would be rewarding his own delay of 13 months and not participating in his child's life, where the Renfros did everything possible to facilitate medical treatment, care, establishing the connection with his siblings, and say, well, we've waited 13 months, done the right thing, hired counsel, have a trial strategy, and go to court and are successful. But because you waited 3 weeks before trial to file your petition for custody, whether you thought or you didn't think you were the child's father, you're going to get a second bite at this apple because you weren't prepared. Or you might have presented different evidence had you had longer to prepare for a custody trial. That would be rewarding his own delay, I would argue.
With regard to the determination of that father would be detrimental to the child, can you address that?
Absolutely. Father had never met this child prior to the custody trial. Father's own testimony is that he worked 60 to 70 hours a week. He lived alone. He had 2 different residences. Neither one of them, he didn't provide testimony regarding suitability of the house. But there was overwhelming evidence that he had a prior record, not just a prior record, but of violence, of domestic violence, of assault, of violating a protection order.
On the 50 to 60 hours a week of work, was the question ever asked of like what his plan would be for childcare or alternative schedules or anything like that?
I don't believe it was. Okay. I don't remember that being in the record. I think maybe the court also took into consideration that father knew that mother was addicted to drugs and didn't take steps to protect this child. And that may have also fallen into a category of detrimental.
Was there any discussion of such in either one of the entries?
Of
the magistrate's entry or the trial court's entry?
That
With regard to that point?
Only that, certainly father had said that he was upset that mother was addicted to drugs. He knew she was pregnant. You're addicted to drugs. I'm kicking you out of my house. And so I think that's the connection, is that this child, if the child was born, was going to be born addicted to drugs.
Was there anything further?
Only the second prong of best interest, I think, is really important, that the court did hear lots of testimony about how well this child was thriving in grandparents' care, had a bond with grandparents, with his siblings, and we heard from a social worker that visited that grandparents' home and did acknowledge that the child was thriving and doing quite well. So, happy ending. Thank you.
Thank you. Unless there's any other questions, thank you for your argument.
Thank you, Your Honors. May it please the court, I only have 4 minutes. There's a lot of, I heard in that exchange a lot of what Mr. Jones should have did or Mr. Jones could have done. And none of those things that he should have done or could have done, a lot of that are kind of judgment based. But he wasn't required by the law to file for paternity in court instead of going through child support enforcement agency. He didn't have an opportunity to establish paternity through a private provider because he wasn't given access to his son, despite the fact that he asked for that. Supervised visit's not going to give him access to his son. He's supposed to do all these things to show that he is somehow interested in his child. But he repeatedly stated in the record, in the hearings, if this is my son, I'm going to do everything I can do to be there for my child. I want to raise him. I'm opposed to custody. He said that repeatedly. So when you talk about abandonment, abandonment is defined as a relinquishment with the intent of never again resuming or claiming one's rights or interest in. At no point did Mr. Jones ever indicate to anyone that he wasn't interested in raising his son, that he wasn't interested in making sure his son had the best of him, that he had the ability to take care and provide for his son. He wasn't given that opportunity on March 10th, 2021. He's restricted from presenting certain evidence. He's almost neglected to a bystander. His role, according to the magistrate that day, was to oppose the petition for custody that the Renfros had filed and to wait for his petition to be heard several months down the line. That's what he was regulated to. He didn't get a first bite of the apple. We're talking about a second bite. He never presented his case. He's never shown why it's in the best interest of his child that he has custody. And legally, he's not required to do that just yet. Because he's a father. He has a fundamental right to raise his son. And that's all he wants. And that right has been usurped through some maneuverings here. And it shouldn't be. We're going to have another trial anyway. Mr. Jones is going to have a trial because right now he can only see his son for a couple hours here and there. He's only ordered to see his son for 4 hours on Father's Day. And that's obviously simply not enough. He can't raise his son. He can't be involved in his son's life. At the time he went and filed for paternity, I think his son was 5 to 6 months old. He found out about court and his son being born and everything else in June, less than 2 months before he initiated that process. At no time did he abandon his child.
Well, what about the delay from June to seeking testing in September?
He sought testing in August, I believe. I don't want to misquote him. He was ordered to appear for testing on September 24th. That's when he was ordered to appear, so he obviously had to file before that. And the hearing date, see if I have the exact, June 9th was when he was mentioned as possible father. August 19th, he appeared in court. And I think counsel indicated at that point, the magistrate said, you need to file for paternity if you want to go forward with anything. So by less than a week or two later, he did just that. He contacted CSEA and filed to establish paternity. 4 to 5 weeks after that, he was at CSEA being swabbed to establish paternity. So where is his delay? Where is his abandonment? Where is he showing evidence that he's not intending to be in his son's life? There's no, much less of a preponderance, there's literally no evidence that he didn't do that. The only evidence that exists are all these, he should have done this, or he could have done that. He knew she was on drugs. He knew he could have been the father. There's nothing on the record that says she told him, you're the dad, you need to come to court. There's nothing in the record that says, that told him, I'm going to have a child in February 2020, you need to be here. The other gentleman who was there, his name was Michael Warren. I'm sorry I didn't have the name earlier. But he was present at the, well, I don't want to say if he's present at the time the child was born. That's who she resided with.
And I believe, did he purport to be the father at that time?
He's purported to be the father. The service was made on, again, I think on John Doe, by the folks. So we asked that this case be remanded. Mr. Jones has not been afforded his full protection of constitutional rights to his son. There's unsuitability finding. Here is unwarranted. There was not a preponderance of evidence shown. There's nothing shown that he was detrimental, or he would be a detriment to his son. We asked the court to remand this case, set it for a custody hearing with the proper standards instituted and the proper protections afforded to Mr. Jones and his son.
Thank you. Thank you both for your arguments this morning. We will take this very important matter under submission and issue you a timely decision. And we wish you both a wonderful week. That concludes.
All rise. The Court of Appeals versus Television is now adjourned.